It's a divorce that police say nearly turned deadly. A wife and mom sent to the hospital for nearly 2 months. Her weight reportedly less than 90 pounds. Doctors say the cause of her health problems was lead poisoning. And the person police now say was responsible, her husband, who court records show had recently taken out 5 life insurance policies on her. Soon, a jury will decide if this chiropractor and dad will spend the rest of his life in prison. We're on the case, presented by Law&Crime. I'm Chris Stewart. Whenever we cover cases like this involving a married couple, I always think back to what their wedding day must have been like. A day that probably had so much love and joy, the ceremony, the reception, and then I just wonder how it could get to this point. In the case we're talking about today, it involves a husband who is accused of poisoning his wife with lead in an attempt to kill her. This is Brian Mann. He was indicted on a charge of attempted murder in September of 2022, and his trial started this week. Now, his indictment back in 2022 came almost a year after a nightmare of a health scare for his then estranged wife, Hannah. The two were in the process of getting divorced when she went to the hospital in January 2022. She's talked about this health scare publicly on Facebook. She wrote, in January 2023, a year ago today, I was admitted into UAB hospital. I had been very sick for nearly 6 months before I had my mom drive me to UAB. The doctors told me if I would have even waited a day later to come, I would have already been dead. Eventually, doctors determined the cause of her life-threatening illness, one that had nearly put her on her deathbed, was lead toxicity. Now, at that point, not only was there a major concern for Hannah, but there was a major concern for her estranged husband, Brian, and their 2 young children. Court documents show that police went to a residence where Mann was, and they asked if he knew how his wife, who he was in the process of being divorced from, could have ingested lead, and if there was something in the house that the kids could have ingested that contained lead as well. Police wrote, quote, Brian led investigators through the house and assisted in looking for something that may have been in the home. Brian told investigators he only knew of Hannah to take 1 vitamin capsule, 1 prescription pill, 1 gummy, and 1 prescription powder. Brian also said that she always ate fast food and that she would pick that up at different restaurants in town. Now, Brian Mann had a great job. He was a chiropractor in Morgan County, Alabama. Hannah, according to court documents, stayed home with the kids. She only worked 1 day a week. On findatopdoc.com, a website that reviews doctors, it read that Brian excelled at improving patients' quality of life by preventing, diagnosing, and treating conditions. So this is someone who you would think you could trust, especially if you were police trying to figure out what happened here, right? Before we get back to this episode of On the Case, I want to bring you a Law&Crime legal alert. Did you know that children under the age of 21 are being diagnosed with serious conditions like type 2 diabetes or non-alcoholic fatty liver disease, and research is potentially linking ultra-processed foods to these outcomes? Our partners at Morgan & Morgan, they are stepping in to fight to hold food companies accountable. They have decades of experience fighting large corporations, and they're ready to stand up for families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or non-alcoholic fatty liver disease, go to www.forthepeople.com/food. You can also scan the QR code on your screen or click the link in the description of this video to learn more. Police advised Brian to get the 2 kids tested for lead. Their results came back negative. But when it came to Brian getting tested, from the court records we read, this is where it seems that things got weird for police. A search warrant says that Brian told police that he was, days later, still looking for a place to get tested. Eventually, Brian went to this hospital in Decatur, Alabama. Brian, the successful chiropractor, told the nurse practitioner there he had done an x-ray on himself and that the x-ray showed a substance in his colon. The nurse practitioner then told Brian they needed to do their own x-ray to investigate further. The nurse practitioner then told police that Brian became, quote, visibly nervous and she thought he may leave. The court records go on to show that Brian stayed for that x-ray, and the x-ray showed a substance in Brian's stomach. But that substance didn't appear to have been there for that long, and Brian wasn't showing any symptoms like his estranged wife was, who was close to death in the hospital. Police say after those hospital interactions, they didn't hear from Brian Mann anymore. This is where it appears Brian starts to become a suspect. A couple months after they last spoke with Brian, police got a search warrant for his medical records. Police say they believe that Brian took lead intentionally in hopes that it would provide the impression that he was being poisoned like his estranged wife. And at this point, police believe that Brian was involved in allegedly poisoning his wife. A grand jury indicted Brian in September 2022 on a charge of attempted murder. In court documents, Hannah noted that the only person who would have been capable of providing her with anything that contained lead was her estranged husband, Brian. Then there was another twist. According to court documents reviewed by WHNT-TV, there was a tip that came in from someone who did construction work at Brian's chiropractic office. That tipster said in 2021, he installed walls in Brian's x-ray room, and the walls had lead, and he left the remainder of the lead with Brian when the project was done. Then we get to May 2023 when police executed a search warrant at the chiropractor's office and collected a sample from the wall of the x-ray room. Now, another part of this story that prosecutors point to as motive is the life insurance policies that had been taken out on Brian's estranged wife. The two were going through a divorce at the time of Hannah's alleged poisoning, and in a filing for March of 2023, her lawyer points out that policies had been taken out to a total of $1.3 million if she were to pass away, and the person who would receive the money for the 5 policies on her life, Brian Mann. Brian has pleaded not guilty to the charge of attempted murder. This week, his trial began. The jury has been selected. When he was arrested, Mann had been out on bond. He had some very strict measures to follow, including spending weekends in the county jail and being on a GPS monitor. According to local newspaper, the Hartselle Inquirer, Mann's defense has pushed back on how the evidence was collected in this case. They claim that police extracted the lead from Mann's estranged wife's urine, doing that in a parking lot of a police station using a bucket. And because of that, it shouldn't be admissible in court. Join us now to talk about this case and this trial is divorce lawyer Randy Kessler. Great to have you here, Randy. This is a shocking story. A lot of twists and turns in how it got to this point. What stands out? Well, actually, I'll start this way. How strong of a case does it seem the prosecution has?
So, stronger than a lot. Not the strongest we've ever seen, right? Because there's no eyewitness. There's no confession. There's no absolute murder weapon. If there was a gun with fingerprints and video cameras, it'd be a lot stronger. It's not a slam dunk case. It's one that the defense probably should take to trial because there are some things that plant some seeds of doubt, like the fact that would you really kill your spouse even if you're going through divorce? The motive might be they're going through divorce. It's, I guess on a scale of 1 to 100, 50, 60% would be my number
Only
of
50.
Conviction.
Yeah, only 50 or 60. I find that interesting because I look and I would say, and you're the attorney, I'm not, so you can bury me on this one if you want. But you look at the lead that they apparently found at his office, and yeah, a place that has X-rays is going to have lead. He had it in his system, but there's reason to believe that he would have taken it maybe just to try and cover that up. There are these life insurance policies. It seems like if you're a juror that there's a lot of things being kind of put forward that would lead you to believe that this is the person who did it.
Yeah. Well, Chris, your question was likelihood of a conviction, not did he do it, right? Because those are two separate questions. Did he do it? Probably. Did OJ do it? Well, a civil jury said yes. And we all know, right? We talk about it all the time in a civil case. Yeah, you just tip the scales a little bit, but you combine that with the proof burden, right? The beyond a reasonable doubt. That's why I lower it to 50 or 60%. It looks like he did it. It smells like he did it. It feels like he did it. It tastes like he did it. He probably did it based on what we know, the little that we know. But is there enough to prove to a jury beyond a reasonable doubt? Do they have doubts? And are their doubts reasonable? You start off with, if I was the defense lawyer, I might even say, yeah, it looks like on average, maybe it looks like he did it. But beyond a reasonable doubt, are you sure beyond a reasonable doubt? Are you going to put this guy away for the rest of his life without an eyewitness, without a confession? This is a pretty serious consequence if you're not pretty darn sure. So, yes, I think he probably did it. I think he would lose a civil case. If there was a wrongful death case brought, he probably would lose that. The prosecution, though, has a higher burden. So that's why I'm not 100% on conviction.
Because I also think about if there was a smoking gun in this case, maybe he was giving her a pill that had lead in it, and you find a bottle of pills that came from his office. I mean, at that point, you would say, okay, there's that smoking gun, but you don't really have that.
Right.
And is that really I mean, how critical could that be to the case that a juror would look and say, okay, well, you have all of this, but you don't have the specific thing that she might have taken that would have led to this diagnosis?
Right. You got a bunch of circumstantial evidence. It's like those little books we had when we were kids that had dots, and you've got to connect all the dots. And are there enough dots there? Well, they were getting divorced, so maybe that's motive. And there was a lead job going on in his office, and he had some leftover lead, and he was a chiropractor, and he gave her pills. And then he went to the doctor later to say, maybe I'm sick too, but the doctor said maybe that's a recent occurrence. So you have all these dots, but does the whole picture, when you connect all the dots, equal a murder conviction? That's the struggle for the prosecution. It's a case worth bringing. They have a good faith basis to bring the case. The question is it strong enough? And maybe the witness's testimony, maybe is she believable? Maybe he takes a stand. I can't imagine he would, because the burden is so high. All he can do is get on the stand and make the jury not like him, because he's got the presumption of innocence. If he sits there quietly, the lawyer can say, you must presume he's innocent. And you cannot use the fact that he didn't testify against him. With that in mind, it's a hard case for the prosecution, harder than a lot of the ones we've covered.
And I know that as we're recording this right now, Hannah, who is the estranged wife, who's the person who ended up having this lead poisoning and nearly died in the hospital, she's on the stand. And I think and this might be a stretch to relate this to this, but in the Diddy trial, you had Cassandra Ventura go first, or early on in the prosecution's case. And then in this case, here you have the person who'd be the star witness. She's also going first. What do you make of that, as opposed to having her be the grand finale for the prosecution?
Well, you lead with your strength for a lot of reasons. Number one, the jury only has so much attention span. Number two, they're going to discount and ignore a lot of the other testimony, waiting to hear from her. So get it out of the way. And number three, if her testimony doesn't go great, plea deals happen in the middle of trial all the time, right, Chris? If the testimony doesn't go great and the prosecution doesn't feel as strongly after her testimony as it did before, they can always cut a deal and offer a lower sentence or some sort of discounted plea arrangement. So I think it's the right choice. You start with your strength. You don't save it for the end, because if it doesn't go the way you want it at the end, there's nothing else you can do. If this doesn't go perfectly, you have other witnesses to rely on. You have other evidence to rely on, but have to start with her.
Another circumstantial clue for the prosecution is 5 life insurance policies on this wife were taken out. The first one was when they were engaged, she said, and that was back in 2020, but there were also some life insurance policies added in 2021 and leading up to her going to the hospital. How strong is a life insurance policy in your experience when prosecuting, as you see prosecutors in cases, that's something you present to the jury, that there was financial interest?
Well, I think they're probably given more weight than they should be given. You and I and most normal people think if you're getting all those life insurance policies on your spouse and then she almost dies, maybe it has something to do with it. But it's really not an element of the crime, right? The prosecution doesn't have to prove motive. They don't have to prove why he killed her or why he was likely the one who have killed her. But if it comes up, the jury is going to have that in the back of their mind. All the prosecution has to do is prove that he did it. And again, that's the difficulty. They don't have pictures of him putting lead in a pill or him feeding her the pill or the pill itself. They have this, maybe it's a motive for him to do it to get money, combined with the fact that they were getting divorced. So if she died, he would get the money if she died before the divorce. If they got a divorce, then all he gets is what the divorce judge gives him. By the way, isn't it curious? I think this is the same judge that's going to handle her divorce, their divorce, as is handling the murder trial. That's sort of interesting in a smaller town, smaller community like the case is going on in.
That's an interesting point. I mean, if you were, I guess, defending this case, would you ask for a different judge? Would you get a different judge, especially in like this is Morgan County, Alabama?
Yeah. And I think they might have done that, and I think the judge denied it. But, the difference is that it's a jury making the decision about guilt or not. It's a judge making a decision about divorce. So I think it actually is more efficient and more economic for everybody to have one judge handle it because the judge isn't making the decision. I probably, to answer your question, would ask that the judge be recused from the divorce case, right? Because the divorce judge is going to make a decision about how to divide money. And he's heard all this horrible stuff about the husband in the murder case. Some of it may be relevant in the divorce case. Some of it may not have been admissible in the divorce case, but he's already heard it. So I don't think it precludes him from handling the criminal case. It might be a basis for recusal from the divorce case. But first things first. First is the murder case.
And looking through some of the court documents related to the divorce, and divorces very well because of the law that you practice, how often is it you have a criminal case that can bleed into, no pun intended here, sorry about that, but it can bleed into this divorce case that's still ongoing?
More than you'd expect. It's rare that it's a murder case, but often, there's spousal abuse, there's spousal cheating, somebody has embezzled money, so there's a criminal case going on. And what happens is the right hand helps the left hand. Sometimes in a criminal case, we know you can't really do discovery. The prosecution can't subpoena the defendant and ask him, did you do this? But in a divorce case, we can subpoena the other side and ask him or her under oath, did you do this? Where were you on this day? So sometimes we get evidence in a civil case, in a divorce case, that helps the criminal case. So it does happen more often than we think. And we work a lot with some of the finest criminal defense lawyers because we're helping them, they're helping us to mutually benefit whichever client we're representing.
He was indicted in September 2022. She goes to the hospital in January of that year. We're obviously now in 2025. This divorce is still ongoing. Are you surprised? I mean, he hasn't been found guilty. I mean, he could be found innocent, but the fact that proceeding is still going on throughout this investigation, how often do you see that?
We see it more than you would think. It's probably the safest bet because a lot of stuff's going to come out in the criminal case that might affect the judge. If a jury convicts him of murder, then certainly, he doesn't need money. He doesn't need alimony. He doesn't need support. He doesn't need a house. He's going to have housing, right? If he's convicted and he's in jail for the rest of his life. So that sort of solves a lot of the divorce problems. And if he's cleared and if he's acquitted, that puts another spin on it. And the wife has to bear the burden of saying, yeah, I mean, I think he tried to kill me, but I couldn't prove it beyond a reasonable doubt. In essence, he may be tried again. And we do see this in a criminal context and a civil context where you win the acquittal on the criminal, but it still comes to play. But it is complicated. But yes, to answer your question, we do see it often where the divorce waits for the criminal case to resolve because you get stuff out of the criminal case that's relevant in the divorce case.
If he's found guilty of attempted murder, he could go to jail for the rest of his life or prison for the rest of his life, or at least a long period of time. What would happen to the divorce case?
It probably wouldn't go to trial. If I'm the divorce lawyer and my client's going to jail, number one, he doesn't have a lot of money to fight the case anyway. He might want to spend whatever money he has left on an appeal of the criminal case. And on the divorce case, if he's going to jail and it's appeal proof or they lose the appeal, he's basically going to say, give me whatever you feel like giving me. I'll take something because it's going to be a while before I can use it anyway. It's usually not much of a fight. Although there are some criminal defendants who say, it's my chance to not be in jail because I can be brought to court for the divorce trial, or I have some connection to my spouse and I can still, make her behave a certain way and make her answer discovery questions. So some people like to fight even when they're already convicted. It just depends on him and the advice he gets.
What would happen? So if he's convicted, he's in jail for the rest of his life. He could appeal, but he can still fight for his assets in divorce court as opposed to, he's going to be in jail prison for the rest of his life. She just gets everything.
He could fight his divorce case even after he's put in jail for the rest of his life. And he might say, I would rather have the money go to my parents or my brother or whatever than just let her keep it all. And maybe he earned a lot of the money and maybe some of it should be his, or maybe some of it was his before the marriage. So there's certainly things you can fight about even after you're convicted. The question is it worth it? What's the cost to fight it? What are you really going to get? And if I was the wife's lawyer, you give him something to make it go away, or you offer maybe more than he could get in court. And I don't know the size of the estate, but let's say the estate's $100,000. Maybe you say, keep $20,000. You can pay for your lawyer. You can pay for your nephew. You can do whatever you want with it, or go to court where, most judges are going to say, you're a murderer. You're not getting anything. Give him something that makes it hard for him to say no to an offer. Make an offer he can't refuse, so to speak.
From some of the divorce documents that we looked through, what stood out to you with how this divorce has been proceeding? I mean, clearly he's accused of a pretty serious crime, but was there anything else that stood out to you?
No, I mean, we have what we call notice pleading, where you just sort of put the court on notice of what the issues are. You don't really want to spell out your entire case in a divorce petition because then the other side knows what's coming. And what if you're wrong? When a client comes to me and hires me and says, here's what I can prove, here's what I want to say, here's what I want, we generally file something that say there's a divorce and we need these issues to be resolved, right? The issues of property division and alimony. If I say the wife did this on this date with this person at this time and it cost this much money. Well, number one, what if I'm wrong because I didn't do my due diligence and I didn't get all the information before I filed it? Or what if I've, oversold it and asked for too much or too little? So generally the papers are generic. These papers don't shock me. I'm not really concerned about what's in the filing. And you can always argue things that are well beyond what's actually in the pleadings.
And just for this story, and I started the intro to this story thinking about some of these cases that we'll cover. And in this case, I mean, fortunately, this woman didn't lose her life with what her husband's accused of. But I mean, you see the end of marriages in your line of work every single day and probably understand that part better than anybody else. But I just think back to the wedding day. It's like, how does it get to this point where someone would be accused of trying to poison their significant other, the mother of their children? I mean, if he's found guilty and all of this is true, I mean, in your experience, how does it get to this point where this stuff can happen?
Unfortunately, it gets there a lot. I mean, we hear people, it's in jest almost every time. I mean, I imagine if it's not in jest, then I've got a duty to maybe tell somebody. But we hear people all the time say, I thought about just taking her out, but I figured it'd be too much money or they joke about it in an evil gallows humor kind of way. But, divorce sometimes is worse than death for a lot of reasons. It's someone you love rejecting you, right? And that's hard. Someone's rejecting me, well, I'll show them. I'll reject them back, or I'll show them. Or if I can't have her, somebody else can't have her either. I mean, human beings are interesting creatures. And unfortunately, when they say till death do you part, people look back on that and they say, well, it didn't say till divorce do you part. The only way out of this is death. And I've even had people think, well, the Bible doesn't let me divorce. My religion doesn't let me divorce. And I'm thinking, the Bible also says thou shalt not kill. But, people get so angry and so hurt that these feelings bubble up. Fortunately, I've never been a part of somebody who's actually been accused of murdering their spouse. I've been on the other side where my client has died and there have been allegations or insinuations that the other side had something to do with it. It's an easy jump because you always want to blame somebody, even if it's an accident or an overdose or whatever it is. You want to blame somebody else to put a finger on it and say, but for that person who we already don't like because they're divorcing my client. We see this a lot more than you would think, unfortunately.
Yeah, and I do feel, I mean, even just in preparing for talking with you today about this particular case, like the poisoning, it just seems like there's multiple cases where we often see that. When you are, and I know you're a professor as well, and you're teaching your defense attorney or future defense attorneys how to prepare for these types of cases, what are some of the things you're looking at in not just the opening statement you're going to make, but how you make an argument when it does seem circumstantially there is so much evidence that is facing Brian Mann to be able to try and connect through to a jury?
On his side, thank goodness for the law. Thank goodness for our country. Thank goodness for our system where you are innocent till proven guilty. And those words would come out of my mouth, and I try to make them come out of the judge's mouth as much as possible in the jury charges. Make sure the jury knows clearly, you will hear the judge say that my client is innocent till proven guilty. You will hear the judge say that you cannot find him guilty unless you find it beyond a reasonable doubt that he did the acts complained of. And you can't just assume and you can't just guess. You have to rely on the law because the facts are the facts are the facts. Yes, they're going through divorce. Ladies and gentlemen, half of all people that get married go through divorce. A lot of people go through divorce. But you got to remember, they loved each other. They had a life together. Is this somebody who would want to not have around? And a poisoning is not an act of, oh my God, I caught her cheating and I just reacted suddenly and it's a passion killing like we talk about. A poisoning, that's a pretty specific charge and that takes a lot of forethought. And when you think about killing somebody by poisoning them, you also have time to think about the consequences. You also have time to think about how you would feel afterwards. Do you think that this is really what happened? And if you think that's the case, have you been convinced beyond a reasonable doubt that that's what happened? I don't think so. You must acquit.
Yeah, and we'll see what happens. This is opening statements today in this trial. A lot of twists leading to this point. Randy Kessler, it's always great to have you on Law and Crime. Thanks for being with me.
Thanks.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.